I've attached in your forms that were given out was a copy of the warrant form, the FED, unlawful detainer. It's a blank, but it's a matter of just filling in the person's name, the property address, and how much they owe in back rent. And that's what gets filed, and that's what gets served. Summons and service on the detainer warrant. You can serve, that warrant can be served on any adult in possession of the property. They don't have to be your tenant. But if you don't serve the tenant and you're seeking monetary damages or back rent, you're only going to get a judgment for possession, not for money. If you don't have, if you can't get anybody served, an adult on the premises, there's another method for obtaining service for the right to obtain possession only, and that's commonly called posting. The sheriff or the process server has to make, and this is an important issue, they have to make an attempt to serve 3 different dates to serve the individual. Personally, I've seen process servers who have gone on the same date at different times, and it slid through. It concerned me, if the judge really looks at it, that their service might be defective. So if you use a process server, just ask them if they have to post on an FED, are they going out on 3 different dates? They have to note the date on their warrant when they return that. The other aspect is, once they do, they have to post a copy of the warrant on the door. This is the process server, the sheriff. The sheriff is going to do all of this. The process servers are moving it, okay, to get money. So you need, whoever you use, make sure that they're doing it right. Because if you get into court and the judge really looks at it, they may kick your case out, and then you got to start all over. You also, there has to be a sending by U.S. Postal first-class mail of a copy to the defendant at the subject property. And then this has to be noted on the warrant itself. So you may have to coordinate with your process server about that letter going out, but he has to do that, and once that is done, posting is effective service for the purposes of obtaining possession only. You cannot get a money judgment on that process. Now, one other issue about, let me go back on the warrant. Even if you don't get service, you want to make sure that you have a money amount that you're seeking in that warrant. Because if you are owed back rent and you say, all I want is possession, and you don't include that in your warrant, and you do get personal service, you can't, oh, I'm going to come back, I got them now, I know where they're working. You can't do that, you're barred. It's a technicality. You didn't include it in your initial warrant, you can't come back and sue them. So you're barred from doing that. So no matter whether you get the money judgment or not, if you have it in the warrant and you only get possession, you still have a right if you find them later. And remember, you have a contract. The lease is a contract. It's a 6 years from the date of the breach to enforce that contract for the recovery of the damages that you suffered, both the rent and so forth. Whether you're going to do that is another issue. Trial or postponement of the lawsuit down in General Sessions, it can't go more than 15 days unless agreed to by both parties. So if a tenant comes in there and says, I need a month to get a lawyer, you go, no, 2 weeks, because possession is critical, and that's what the statute's written for. You want to grant that to a tenant, that's your decision. But I always try to do no more than a week myself. But they sometimes, most of the time, will get 2 weeks. But don't agree to go beyond 2 weeks. Judgments and decrees. Again, this goes back to what I was just saying. The General Sessions judge will make a decision about how much rent arrearage is owed, any damages, and interest and attorney fees if there's an attorney involved, and also awarding possession. And it's critical when that judgment is awarded by the court. This is another reason you have the money amount in your warrant. Even if you're getting a judgment for possession only, you want to make sure, because on that warrant, the judge is going on the judgment. He or she will say this judgment is based on a breach for non-payment of rent, or is not based on a breach for payment of rent. Yes, sir.
Is there a statute of limitation on how far you can go out to find the people and get your money?
You've got 6 years from the date of your breach of your lease. Once you've declared a breach, you've got 6 years. It's a contract, so that's the statute of limitations for bringing an action to recover for back rent or damages. Is that it? Okay. But going back, make sure that you ask the judge to show on the warrant, on the judgment, that it is for a breach of non-payment of rent. That affects appeal rights, and we'll cover those in a moment, but it's critical that you have that and that you get the judge to do that. If you don't, and they make a mistake, fail to note it, it could affect bond and appeal rights. So for your protection, you want to request that. The only thing that may not be included in this lawsuit that you still have a right to come back and sue for damages later would be damages to the interior of the property, particularly if they have not vacated and you're trying to get them out and they're in possession. You haven't had the right to get them out. You're suing for the back rent and possession, and then you go in after a judgment for possession and the money on the back rent is awarded to you, and you find out they've knocked holes in the wall, they've taken down fans, they've taken light fixtures, and then you have to go back, give notice of the, well, you don't have to give notice since they vacated and you were moving on, but you have to prepare your list of damages and then re-sue them for those monetary damages as it relates to those repairs, which is a separate cause of action. So that's a caveat to that. That's an exception to that. You can't execute your writ of possession or on any money judgment until after the expiration of 10 days. The execution of the writ, I've given you a copy of the writ that's attached as one of the exhibits here. You're entitled to issue that writ on the 10th day, and you can have the defendant removed and all of his property cleared. Now, there are some rules relating to removing the person's property from the premises. I got a writ of possession. The landlord, and this is an amendment, the landlord has to designate, or his representatives shall move the person's property out of the premises. This is really strange. You have to move it away from the door where it won't block the door, and you have to move it in a reasonable location. You don't put it out at the street. They don't want you putting it out at the street, and it remains there for 48 hours. And as long as you put it out there, you're not responsible for whatever happens. I mean, in all honesty, you're putting up this is a yard sale, come help yourself when you do that. Whether you put it on the street or not, because once you do that, it's fair game. You're not there to guard it. You're not required to guard it or do anything to it. If you comply with this statute by putting it out away from the front entrance where it doesn't block, but away from the street, you know, it could be out by the front of the house, on the corner of the house, away from, but it's out there, and at night, who knows what happens. You know, people come by, even during the day, they see something, nobody's there, they pick up what they want. A lot of stuff gets but you're not liable. As long as you've complied with this, you're not, unless there's malicious act or malicious omission on the part of the landlord. But that's one of the processes that you have to do in removing personal property from your premises of the tenant. Now, there's another exhibit that I have attached, which is the City of Memphis new policy on evictions, and that's attached, and it spells out, this went into effect March of this year. You have to box up this stuff. Okay? Isn't that special? Now that's if you're going to put it out on the street. You have to put it in strong, durable plastic bags or boxes if you're going to end up, after the 48 hours is over, and put it out in the street. You also have to contact the City of Memphis. And there are numbers there on the form on who you have to contact. And you have to give them 24-hour notification. I'm getting ready to put this stuff on the street or by the right-of-way, and y'all have, so they know that they can come. They need to come and pick this up. Now, the last provision of this ordinance does state that if the city's not needed to dispose of this, in other words, if you're going to take and dispose of it because it's really trash. Now, if it's a bed, if it's a couch, end table, things like that, depending on whether it's broken, whether it's, whatever, you have to make the decision whether you're going to trash it and be done with it and take pictures of it, or you're going to let the city come and get it. Depending on how much of that it is and how much you think it's worth, whether you want to expose yourself to that, the decision sure is whether just to go ahead and put it in the back of a pickup and take it to a place and dump it. But that's a decision you have to make. The safest bet is to call the city, tell them it needs to be picked up, make sure that you've complied with the ordinance of the city. But you can't do that for 48 hours. At the end of the 48 hours, you got to give the city 24 hours notice.
What if you're not in the city limits?
I'm sorry?
What if you're not in the city?
This applies to Shelby County too.
Oh, it doesn't.
Yeah, it's Memphis, Shelby County.
Okay.
So.